We are going to go ahead and get started with today's presentation on tips for avoiding a will contest. We'll go ahead and get started. If you have questions at any point, just let me know. But we will get started with this. First thing, I'm Lauren Ward, and I'm an attorney with a business law firm here in Spartanburg, South Carolina. And today's webinar is going to be on how to avoid a will contest. If this is your first time joining, I'm a graduate of the University of South Carolina, undergrad and School of Law, and my main practice areas are estate planning, Medicaid planning, and business planning, as well as probate work that comes kind of in the estate planning category. This webinar is being recorded, so I'm going to put it on YouTube afterwards. So if you want to share with any of your family and friends, feel free to do so. But today we're just going to kind of go over how to avoid a will contest by making sure we have the right requirements for a will on the face of the document, mental capacity, and understanding what actually happens when you have a will contest. What is that process? So the first thing, we have some basic requirements for a will here in South Carolina that comes from the Uniform Probate Code. Your will needs to have two witnesses. So your will needs to have two witnesses. That seems pretty straightforward. These witnesses need to be disinterested witnesses is best. So that means these should be people that are no party to the will, no family members. You want to have people that witness it that are completely unrelated. So if you're getting it done by an attorney, typically in our office, you're going to have me as a witness, and you're also going to have my admin or another attorney as a witness as well, because we're two disinterested parties. We have no interest in your estate. And that's really important. A lot of times people let their wife or husband be a witness or their children, and that's not the best way to do it. That could lead to will contests because, for one, they're getting something under your will, so you don't really want to have them as that. And that could be your will isn't valid if you have these interested witnesses who shouldn't have been. So you definitely want to have two disinterested witnesses. So they're not a beneficiary of your will, not a family member. You want to take it outside of that. In South Carolina, we don't require a notary on the will. Doesn't mean you shouldn't have one on there, but it's technically not a requirement. So when I draft a will, there's what's called a self-proving affidavit. Or with this self-proving affidavit, what it means is there's this extra page added to your will where it is notarized and everything. So if your will comes into question, they don't have to call the witnesses into court. The document speaks for itself. So that's why you like to have that self-proving affidavit or notarization to a will. That helps with the validity of it if there is a will contest. While it isn't required, it's something you really need to have on that will to just help with validity and avoiding will contests. Another thing is, once you set this will up, do not go back and handwrite on it. Many times people will want to scratch out, I'm going to take out my daughter. She's made me mad. I'm just going to scratch that out. Don't do that. You want to make sure when you update your will, you go through the actual proper requirements again. You don't want to just have scratched out because the court isn't going to accept that. And that is a way that leads to a will contest. So make sure every time you update your will, it is properly done. We're not scratching out. We're not handwriting on it. The only thing we're going to handwrite on is if your will allows you to have a personal property memorandum, which you can handwrite on that one piece of paper. And sometimes we have these with wills, and this allows a person to give their personal household items away, not like cars, not cash, not real estate, but things like jewelry, antiques, furniture can be on that personal property memorandum. And that is the only thing you can handwrite on. But on your actual will on itself, don't handwrite on it. Don't scratch anything out. If you want to update it, make sure you see someone to properly do that, where you either draft a new will, draft a codicil to the will, and it has all those formal requirements. Because scratching out and handwriting on it is one way that's definitely going to lead to a will contest from your family. So what is actually inside of the will that really needs to be there to help avoid the will contest? So you want to have that personal representative listed in your will. Some people know this as an executor, but that's the person that's going to handle probate for you. So you definitely want to have that in your will. You need to describe how you want your assets distributed and make sure your will actually matches this. You want to go through your will and say if you want your house to go to your daughter, you want your 2 cars to go to your son. You want to see that clearly listed in the will if that's something specific you want to go to each child or grandchild or friend or whoever. You want to look and make sure your assets are actually going to the people you want them to go to. You want to understand inside your will, there's things like specific bequests versus the residue clause. So pretty much if you want certain assets to go to just a certain person, you may need to list those as specific bequests. So saying, I want my house to go to this person. I want my car to go to this person. If you just want your estate to go, whatever you have at the time of your death to split equally between your 2 children, you're not differentiating. You're not really caring about the assets that go to each one. You just want them to split everything 50-50. Then you use the residue clause to say, everything is split between my 2 children 50-50. So you're not listing anything specifically. You're just saying everything is split between these children. But you really want to understand if you're wanting just a certain asset to go to one person and not as part of the residue of the estate, you want to have that listed. But if you don't list certain assets, the residue is like a catch-all. Everything in your estate that hasn't specifically been listed is going to pass through the residue clause in your will for those probate assets. If you have minor children, you want to make sure when you're doing this will, you go ahead and list those guardians for those minor children in the will. So it's just, you want to understand what's in your will. If you have questions while you're reviewing it with your attorney, ask. You want to make sure you understand what these clauses mean, what this will means, and making sure that your wishes are properly in there and that it is how you want your assets to be distributed. So take the time to look at your will, review your will with your attorney. So we've talked about just the face of the document and what's in the document, but you have to have the mental capacity in South Carolina to be able to execute a will. So the mental capacity for a will is pretty simple, pretty low bar for mental capacity in regards to other situations. The capacity to have a will is simply, you have to know what you have. So you have to know the extent of your estate, and you have to know who you want to give it to. This is a lower bar than like a contractual capacity, but you still have to know what you have and who you want to give it to. So you want to make sure you get this will executed while you still have full mental capacity. There is, if you've been diagnosed with Alzheimer's, dementia, or have some type of traumatic brain injury, those could all be things your family could bring to contest the will because instead you don't have mental capacity. So it's really important to get this will done while you know you have mental capacity, because if you're 90 years old drafting a will and you've been diagnosed with Alzheimer's, there's a good chance that if your family has a will contest, they might have some really good evidence to get that thrown out because of you not meeting the mental capacity. If you're drafting this will at 75 years old and you're completely mentally competent, take care of yourself, live by yourself, all those type of things, it's going to be hard for them to prove you didn't have mental capacity to do your will. So you definitely want to do it while you're young enough or when you're in a good state of mind. So that way you don't have to worry about them contesting it based on your mental capacity. A lot of the will contests I get do kind of revolve around this mental capacity issue because the parent has maybe been diagnosed with dementia. The parent may have been diagnosed with a traumatic brain injury. This came back up later in life. The parent may be a severe diabetic and have sugar levels that aren't in control. And when that happens, they don't have mental clarity. Typically, if you're coming to me to make a will and we want to make sure you have mental capacity, I'm going to ask the person a series of questions. And so if something happened and your will is contested, I could get called into court and say, well, in my opinion, they had mental capacity because they knew A, B, C, D, and those type things to help make sure your will is actually accepted by the probate court. But if an attorney doesn't think you have mental capacity, a lot of times they're not going to draft the will for you at that point anyways. That is a factor in having an attorney draft your will. You'll have a witness to say, yes, that adds validity to it, that somebody outside the family believed you had mental capacity to handle this will. So just overall, some basic tips to make sure the will isn't contested. We want to make sure we do our will while we have mental capacity to do so. Don't keep putting it off. Don't say, oh, I'll do it in a few months. I'll do it in a few years. Don't put it off. Do it when you have mental capacity to do it. Making sure your will meets all those proper requirements, like the 2 witnesses, and has everything in there you want to be included in your will. And having an attorney draft it can be helpful. I have a lot of people ask about, what about a no contest clause? So yes, we can add a no contest clause to your will. Doesn't mean somebody's not going to contest your will, but typically a no contest clause has to have some meaning for somebody not to contest your will. So say you gave your estate 1/3 to one child and the other child got 2/3. And you put a no contest clause because you don't want the child that just got 1/3 to get angry. Well, the no contest clause, you could say if you contest it and you lose, you're going to lose all your rights and everything's going to go to your sibling. So that means they could possibly lose 1/3 of the estate if they lose. So that puts some validity to it that they're actually losing something. But say you put a no contest clause in it and you've written that child out. What are they going to lose besides paying attorney's fees and contesting the will because they're not getting anything under the will? So that's a conversation you need to have individually with your attorney to see, is it worth putting in and what is the actual impact of it on my will? Sometimes it can be worth it, sometimes it's not. And you don't need to do just, I'm going to give my one child $5 just to say in here, do that. I think that kind of could add to some contesting. You can do it if you want to, but there's no need to do that if you're just wanting to write somebody out of your will, because in all reality, you do not have to leave your children anything in your will. So if you're wanting to not give anything to a child, that's completely fine. Doesn't mean that child isn't going to get mad and contest it, but you don't have to leave your children anything. So this is what we talked about before, but you want to make sure you understand all the terms of your will. So there's a lot of legal terms in a will. Sometimes there's terms such as issue, descendants, executor, per stripes. Make sure if you don't understand these terms, you ask questions so you understood what they mean. Because sometimes these are legal terms and they're not terms we use in everyday language. And you get home and you're like, what does this mean? Always feel free to call back and say, I don't understand this term. What does this mean? Or when you're going through the document, ask those questions because you want to understand what these legal terms mean in your document, because that can make a difference on how things happen in your estate plan. So definitely make sure you understand your will and make sure that when you're going over it, you ask questions, and don't be afraid to ask questions, because that's what we're here for, is to answer those questions and make sure you understand what's actually in your will. So speaking of will contests, a lot of times they happen sometimes because people don't update their wills and they tell family members other stuff. So say you tell your grandchild, I'm going to leave you this house, but then you never go update your will to do it. That can lead to a will contest. So if you're wanting to update things, make sure you actually take the time to go see that attorney and properly update the will. I personally recommend checking in every 3 to 5 years, possibly if there's laws that have changed that could impact things, but also to make sure you still understand what's in the will, you understand who it's going to, and make sure there's nothing you want to change in it. Also a good time to update your will that's going to help with will contests is anytime there's any major life events. So if there's a death, a birth, divorce, remarriage, anything like that that impacts your will, you're going to want to check in and make sure you don't need to update your will at that time. Or if you do need to update your will, getting that taken care of. For instance, if you've maybe left everything to your 2 children and one of your children predeceases you and you don't really like those grandchildren, then maybe you want to come back and update that will so everything goes to the other child. You just kind of want to make sure anytime there's a life event that you understand what happens because of this life event with your estate plan. It's always a good time to check in. So on the average, every 3 to 5 years, making sure there's no new laws, nothing's changed, but any major life events, whether they're happy, like marriages and grandchildren, or they're hard events like divorce and death, we want to check in because that'll help with those will contests. So after you've executed your will, what should you do with it? You want to keep it in a safe place. So if you have a safe or a safe deposit box, those are great places to keep it, but let somebody know where it is. If nobody knows where your will is, that's not going to do any good, but definitely keep it in a safe place because probate is going to need that original will. If you don't have the original will, it's a lot harder to get a copy in. So you want to have that original will. If you don't have the original will, the court presumes you revoked your will. So that means that your family is going to have to petition the court to get this copy in, which is a lot harder process than just having that original will. If you realize you've lost your original will and you know you don't have it, you want to go re-execute a new will. So that way you have that original. So when something happens, your family has that to take to probate. Now here in South Carolina, we don't record wills ahead of time. So you don't have to go take it to the courthouse or anything. It's really just keeping it in that safe place and letting somebody know where it is. Typically, you want to let your personal representative executor know where it is. So if something happens to you, they can get it into probate court to get the estate process started. But not having that original will makes it a lot harder on your family. And that's where will contests come in, because maybe you wanted this original and you lost it, and now it's a copy and the court's not letting it in, or maybe you did revoke it and that's what you wanted, but nobody knows because you're not here to tell us anymore. So should I tell my family about my will is something that a lot of people always ask me. At the end of the day, it's a personal decision. You don't have to tell them the contents of your will. You may want to, you may want to let them have a copy. That is completely personal on how you want to interact with your family. Completely 100% your decision. But the big thing is, once again, letting somebody know that you have a will and where its location is. So that way, if something happens to you, they know where the will is to be able to take it to probate court. You don't have to tell them what's in it. You can have it locked up, but they need to know it's there. And if it's in a safe deposit box, you don't want to give them access to the safe deposit box, that's okay. But that would allow the probate court to issue an order so they could get in that safe deposit box to get your will. But you want to make sure that they do know where the location is. So that way, if something happens, they can have the will for you. This needs to be somebody you trust you tell this to, though. You don't need to tell this to somebody you don't trust, because you want to make sure this person is actually going to go get your will and take it to probate court like they're supposed to. So say you've done everything right, but there is a will contest. What's going to happen? And it's an actual court proceeding. It is like a trial pretty much. You have to file a formal summons and petition with the probate court. This has right now $150 filing fee. This is like filing a complaint in civil court. This is an actual petition for a court proceeding. And then we have what's called the discovery process that we typically will engage in during a will contest. That's things like interrogatories where we're asking questions of the other side. We're asking them to produce documents. We're taking depositions. You know, if it's a mental capacity situation, we're probably going to depose the doctors the person had to see what that doctor says, if they had mental capacity or not. We're going to look at taking depositions of who opened the safe deposit box. What did you do with it? If we're worried about where the will is, we're going to look at deposing all the families and parties involved, possibly the draft and attorney. Maybe we are going to depose people and take statements like you would in any type trial situation, because we're trying to say we're having to either prove that the will was valid or we're trying to prove that the will was not valid. If you file a will contest, the presumption is the will is valid till you overrule it. So typically the burden is on the party contesting it, but you want to make sure, if you're the attorney that is representing that the will should stay, you have evidence on your side too, because while the presumption's there, if they're going to bring enough presumption, you have to rebut it. So you're going to have all these formal parts of like a real trial situation. Then we may even look at mediation. Mediation is currently not required in probate court, but it may be at some point in the future. Right now, mediation is required in courts like family court. So I could see in the future the probate courts possibly moving to make mediation mandatory, but we don't know right now. But a lot of times we still mediate cases because that helps to work out a possible settlement. But then if we don't reach a settlement, we don't go to mediation or mediation doesn't work out, we're going to have an actual trial in front of the probate judge. This won't be a jury trial. You're just going to be in front of the probate judge, but this is an actual trial where we put witnesses on the stand, produce evidence, and then the probate judge is your trier of fact, and they're going to decide if the will contest stands, if the will stands, or if the will contest is valid, and overrule the will. But it is a formal process in probate court. It is a serious process. So that happens when a will is being contested. So overall, that's kind of the process for making sure for what happens in a will contest. So reminders, we want to make sure our will meets the technical requirements with those two disinterested witnesses. We probably want a notary or self-proven affidavit with it. We want to do our will while we have mental capacity. We want to keep that will in a safe place because we need that original in probate court so we don't have to have these formal hearings. And we want to see our attorney to update our will when we have changes that we want to make or when there's life events. We don't want to handwrite or scratch on that will to change anything. So overall, my final thoughts on this is just, it is important to have a will. Having a will helps avoid that family drama because you've laid out what you wanted. Keeping the original is important. You need that original for probate. And will contests are very serious court proceedings. So knowing that that's not just something people enter into lightly, it is a serious court proceeding. Once again, I'm Lauren Ward with a business law firm. We're here in Spartanburg, South Carolina. If you have questions, 864-699-9801 or my email, lew@abizlaw.com. If you have any questions or want to get your will set up or make sure everything looks right, definitely feel free to email me or give me a call. Or if anybody has any questions now, I'm happy to take a minute to answer those if anyone has anything. Well, thank you all for joining us today. We'll have another webinar coming up in the future. We're going to deal with what happens if you do get a divorce and handling those estate planning documents. While I don't do divorce law, it is still an important time to deal with estate planning when you're going through that process. But I will be back with that in the future. Please keep following me on LinkedIn or YouTube to get our Facebook page for the firm to get more information about upcoming webinars and some info on us. But thank you all for joining. And if you do have questions, feel free to give me an email, give me a call. But I look forward to any questions you may have. But hope you all have a great day and join us for our next webinar coming up.